Hello and welcome to our second webinar in this series on developments and themes for 2022. I'm Anna West, a Knowledge Counsel in the Employment team.
I'm Elliot Roberts, one of the associates in the team.
And I'm Moji Oyederan, Senior Associate and Business Immigration Specialist.
Today we're going to be talking about recruitment and retention issues. This is likely to be a key theme for 2022 for two reasons. One is the current labour shortages, with job vacancies across the UK rising to a record high of 1.2 million in the 3 months to November last year. And the other reason is a trend which you may have read about called the Great Resignation. It's a term which originated in the US and refers to workers leaving their jobs at historic rates last year. So employers are more than ever needing to retain the staff they have, as well as recruiting new ones. We're going to talk about the sort of steps employers are taking, as well as the employment and immigration law developments in these areas. Let's begin with retention first. Elliot, one thing which seems to be linked with the Great Resignation is that there seems to have been an increase in employee grievances and other complaints, such as whistleblowing, over the last year or so. Is this something you've seen as well?
Yes, I agree. And I know there's something that we're seeing across the team at the moment. The market is shifting towards an undersupply of workers in a number of industries. So employees seem to be more willing to speak up if they have any concerns in the workplace. Some of these concerns can make their way to the media and become very highly publicised. We've seen that recently with some companies such as Brewdog and Apple and Facebook, or Meta as they're now known. And this really highlights the significance that employees are placing on a business's culture and ethos, and directly influences employee retention in that regard.
And unsurprisingly, perhaps, we are seeing a significant increase in investigations work in our team, which comes about for a few reasons, doesn't it?
Yeah, it sure does, Anna. There is, of course, a natural increase in investigations due partly to the increase in grievances and complaints from employees. The increase can, however, also sometimes be down to investigations into historic issues because of concerns that were not done properly at the time. This is particularly the case where employees have a distrust of the way they feel their employer might investigate matters, which in turn has led to employers wanting to be able to clearly demonstrate an independent and transparent investigation is being carried out. For this reason, we are seeing an increased use of external investigators, such as barristers, to carry out investigations on a company's behalf. Now, although we have carried out investigations work for clients across various sectors, we have seen our regulated clients being particularly concerned to ensure that investigations are carried out thoroughly, which I understand is because the FCA continues to be very focused on this area, doesn't it, Anna?
Yes, that's right. The FCA strongly believes that firms with a healthy culture are less prone to misconduct, and the FCA measures and assesses the culture of the firms that they regulate. One particular aspect of culture which the FCA really highlights is the need for employees to have what is called a psychologically safe place to work, in which they can speak up when they see something they think is wrong, and without fear of retaliation or any other adverse reaction. And it's not just about ensuring there are no bad consequences of speaking up, but also about making sure complaints are taken seriously and investigated properly. And if there has been any misconduct, to shine a light on it and take steps to make sure it doesn't happen again. And this cultural focus is not just limited to regulated firms. The Financial Reporting Council, which sets the corporate governance code for listed companies, at the end of last year published a report on creating positive culture, which aims to promote good practice and positive working culture in companies. This report also emphasises the importance of psychological safety in the workplace and encouraging everyone to speak up and share concerns if they have them. Even though these initiatives are aimed at regulated or listed businesses, all of those principles, of course, make sense for all employers to focus on.
Yes, it's interesting to hear about this theme of being able to speak up internally. If employees do feel able to do this, then you would hopefully avoid the sort of Brewdog public complaint that I mentioned a little bit earlier. But what sort of steps can employers put in place to encourage this open speak-up culture?
Well, obviously, it is important to have a clear whistleblowing, or as it's probably better termed, speak-up policy in place. We are finding quite a few clients are wanting to review and update their policies, which have often been the same for a number of years and are often quite narrowly drafted around the whistleblowing laws, whereas it's better to have a broader policy which encourages employees to speak up about any concerns, even if they don't strictly fall within the legal definition of whistleblowing. They should also be offered as wide a range of speak-up routes as possible. So, for example, external hotlines or an online complaint system as alternatives to going to their manager or HR or compliance. But of course, it's not just about the policy, as you need to have full buy-in from the top of the business and for that to be made clear to employees. One thing we recommend to clients is rolling out training on the policy to all staff and having the managers receiving the same training as well, which helps to show their commitment to the policy. So yes, having an open speak up culture in which employees can feel free to raise concerns and where these are taken seriously and investigated properly is really important for a number of reasons, not least to help to retain staff who may be unhappy and might otherwise decide to move on. Sticking with retention issues, but moving away from broader culture aspects, let's look at what we're seeing in terms of measures to improve day-to-day life for employees and encourage them to stay. Are you seeing many employers offer financial incentives? And if so, what sort of thing is being offered?
Yes, there are a lot of reports of employers offering financial incentives to encourage employees to stay. For example, Sainsbury's has recently announced that 150,000 workers will be given a pay rise and annual bonus. In the US, there have been reports of Facebook and Apple offering share incentives worth close to $200,000 to convince employees to stay. And a recent survey of professional services firms here in the UK found that 43% of firms plan to increase pay throughout the organisation to reflect the fact that new starters are now being offered more. So this is a theme across a diverse range of industries.
And of course, in terms of non-financial improvements to people's working lives, the big moves we've seen are towards more flexibility in terms of when and how people work.
Yes, that's right. A recent survey by YouGov found that 57% of workers wanted to be able to continue working flexibly from home all or part of the time after the pandemic. Offering this flexibility to employees is therefore clearly a way to improve day-to-day life for a large number of employees and continue to encourage them to stay. Looking at our clients and media reports, it seems the majority of employers are planning to offer some sort of hybrid working on a permanent basis after the end of the pandemic. There are exceptions to this, though. In particular, a couple of the large banks and US law firms have come out and said that they're requiring everybody back in the office. This said, hybrid working does come with a number of challenges which have to be worked through. For example, will employees be permitted to work from abroad, either temporarily or on a more permanent basis? Will moving out of London impact pay? There are reports from a large number of companies that adjusting employees' salaries based on the cost of where they live. Also, there are various considerations around management of employees, including work allocation and performance processes. We have produced a hybrid working checklist which covers all of these issues, which you'll be able to find at the link at the end of this webinar. It's worth remembering that the government is currently consulting on changes to the statutory flexible working rules. The main proposed change is to make the right to request flexible working a day one right. At the moment, you can only make a statutory request once you have 6 months service. So this consultation also suggests that there might be changes to the list of the grounds on which a flexible working request can be refused. So at the moment, there is a specified list you have to choose from. Many employers already have a flexible working policy, which allows anyone to request flexible working, even if they don't have the 6 month service to make a statutory request. But I expect we will see an increase in flexible working requests if it does become a day one right under statute. And that does give rise to a few practical considerations.
Yes, it does. What a lot of employers find tricky and rather unfair about flexible working is that it works on a first come, first served basis. So the more employees there are who want to work flexibly, the fewer options there are for those who come later. You might agree a request for several employees, and then a year later, someone else asks to work flexibly and you have to refuse because there's no more flexibility within the team. And this can feel rather uncomfortable. Also on the same theme, you might be dealing with competing requests from different employees, and you know that you won't be able to grant them all. Some employers decide to prioritise employees who have childcare or other caring responsibilities or need to work flexibly for health reasons, because there is a discrimination risk if you refuse their request without justification. I think the best approach is to deal with all requests on a case-by-case basis and balance the needs of the employee to work flexibly against the needs of the business. And you can see that you might take the view that having caring responsibilities is a greater need than, say, pursuing a hobby. But I agree, the greater the increase in flexible working requests, the more employers will be having to deal with the competing needs of different individuals.
That's right, and I've definitely seen a few of our clients having to deal with these issues recently. The one thing we have seen quite a bit since pandemic is employees who wanted to return to their home country, often in Europe, but carry on working remotely for their UK employer, which raises a few issues to think about.
Yes, it does. This is something of a topic in itself, so I wasn't planning to go into a lot of detail on this in today's webinar. But from an employment law perspective, you would need to think about employment status and whether the individual should be a consultant or employee, which will depend on the employment laws in the other country and on the tax position. Also, there are practical questions to address around managing an individual who moves abroad and how often they need to come here. There are also data protection issues to consider as well, because there will be transfers of data outside the UK when someone works abroad. And of course, there are tax considerations, including whether the employer is creating a presence for tax purposes in that location and what tax or social security payments they may need to make in that country. And if the business is FCA regulated, there will be regulatory issues to consider as well under FCA rules and the rules of the relevant local regulator in that country. There'll be immigration requirements to take into account too, under the particular country's rules. Some employers are implementing a working abroad policy to sit alongside the hybrid working policy to cover some of these wider issues, although you would always need to look closely at the individual situation because that will vary depending on which country they want to move to. If you want to hear more about all of this, we did a webinar on working abroad, which there is a link to at the end of this webinar. So please do watch that if it's of interest to you.
You mentioned just now that one of the things you will need to think about if an employee works remotely abroad is how often they will need to come to the UK for business visits, such as meetings or trainings. And during the height of the pandemic, people were not really traveling, but now we are seeing a lot more questions coming up about business visits, which of course are less straightforward since Brexit. Moji, can you tell us about the rules around business visits to the UK?
Yeah, I think the first thing to flag here is that there are restrictions on what visitors can or cannot do in the UK. And following Brexit, as you've said, there are changes and EU nationals are now subject to the same restrictions for business visits to the UK. Fundamentally, a visitor will not have permission to work. So for a remote worker, they'll need to be very clear at the UK border that they're not coming here to do their normal day job from here. Also, some nationalities will need to apply for a visa in advance of coming here. So someone visiting from Russia would need a visa to be issued in Russia before they actually travel to the UK. Now, even where the business visitor doesn't need a visa in advance, say a US national or a French national, say, the requirements and restrictions must still be considered. And it's usually a good idea for them to carry a letter from the employer to confirm their overseas-based employment and the reasons they're coming to the UK, just to facilitate their entry at the border. Business activities in the UK will need to fall within the scope of what is permitted, and individuals will need to be prepared to explain why they're coming and confirm that it meets the requirements and show evidence of return travel booking as well as sufficient funds to cover their trip.
Moji, you mentioned that there are restrictions on what you can and can't do as a business visitor. So what sort of things would you be able to do?
That's a good question. So as a remote worker, you could, for example, come to the UK for business meetings with colleagues in the London office, or to meet with contacts, attend conferences or consultations. You could come for training sessions, but these would need to fall within strict restrictions. The key thing is, as a business visitor, you can't do your day job in the UK, but you could check in on your emails or take calls relating to your work outside the UK. But the main purpose of your trip shouldn't be to work here remotely. The other thing is the duration of visits also generally need to fit within the planned activity that you say you're coming to do, and should generally be of a short duration on the basis that your work is based outside the UK.
There is certainly a lot to think about on that topic. Let's now move, though, on to look at issues arising around recruitment. Some of these overlap a bit with retention issues, but some are also different. One challenge that we hear a lot about is the skills gap, where employers are finding it difficult to hire appropriately trained workers. What are we seeing employers do to address this, Anna?
There are a couple of different routes we're seeing. One is the use of apprenticeships, and the government was offering a £3,000 incentive payment for each apprentice who is hired up until the 31st of January. We've been reviewing apprenticeship agreements for clients and also looking at the terms of their contracts with apprenticeship training providers. We're also seeing a number of clients recruiting employees with a specific view to training them up for a specified trained role that they have shortages in, sometimes with an extended probation period to cover the training that's needed, and with their continued employment being conditional and then passing that training. So we've been reviewing employment contracts and training agreements, including the terms around repayment of training costs, to make sure the employer has all the protections they need if that training doesn't work out as planned. Elliot, you talked earlier on about the large numbers of people who want a greater degree of flexible or remote working. Is this something we are seeing employers using to attract candidates?
Yes, it definitely is. It is more and more common for companies to publicise their internal policies as a recruitment tool. This extends not only to publishing flexible working policies, but also other policies that are employee favourable. The first thing that comes to mind here is family-friendly policies, which offer enhanced benefits. This was a trend that has likely been helped along by a 2019 government consultation, which suggested larger employers should publish these policies on their websites. Now, although we haven't yet had the response to that, so we don't know whether it's going to be a requirement in the future, it does seem to put it in the forefront of the minds of people that are thinking about these policies.
I wanted to pick up on something we discussed earlier about some employers looking to recruit from overseas if they can't find suitably qualified candidates based here. That might be to work remotely from abroad or to come here to work. If the individual is working remotely from abroad, then there are potentially tax, social security and regulatory issues, as we already mentioned. But Moji, can you tell us about UK immigration rules in this situation? How do they apply when someone is recruited from overseas? And does it make a difference whether they work remotely from abroad or come here to work?
Yeah, it does actually make a difference where they'll be working. Employers in the UK have a duty to prevent illegal working and could be subject to illegal working penalties if they're found to have employed somebody who doesn't have the permission to work, and fines can go up to £20,000 per illegal worker, and there's also potential criminal liability, so it is quite a key issue. The good news, though, is that the illegal working regime applies to employees working in the UK. So if you recruit someone to work abroad for you and their role will be entirely based abroad, then there would be no UK right to work issues. As Anna's mentioned, employers will need to think about the permission the individual has to work in the country they're based. And she's also touched on the other considerations in relation to the other sort of employment law angles, and we've picked up on the business travel points. Now, if you're recruiting for individuals to be based in the UK, the work visa regime is generally covered by the employer-sponsored visa route. This allows employers to apply for a sponsorship license and receive pre-approval to sponsor employee visas. Now, there are two main visa categories under this, the intra-company transfer and the skilled worker visa route. There's also a minimum skill level and salary thresholds that need to be met for each category. We've been seeing a lot more clients who weren't previously sponsors actually going ahead to make applications for sponsor licenses due to the sort of recruitment pressures they're seeing. And we're certainly seeing a higher number of sponsored visa applications going through. Now, it's worth mentioning that EU nationals who arrived in the UK by the 31st of December 2020 are covered by the EU settlement scheme, and they had to apply for status by the deadline of the 30th of June 2021. They can prove their right to work under the scheme, so they wouldn't need a sponsored visa. So recruiting people already in the UK would probably be covered by that scheme.
And as we know, employers have to check the immigration status of new recruits before they start work. I know this has been possible to do remotely throughout the pandemic, and this is going to become permanent now, isn't it?
Yeah, so since March 2020, so during at the height of pandemic, when everybody was working remotely, employers have been able to complete or write work checks remotely using copy documents and over video calls where they will check the individual's details over a video phone call rather than in-person checks. This adjusted process is, however, set to end on the 5th of April, and new rules will then come in from the 6th of April. The new rules will mean that employers actually need to ensure the checks for employees who have biometric residence permits or BRPs, or biometric residence cards or BRCs are completed online, as this will now become mandatory. At the moment, you could check the standard normal process is to check original documents, but it will now become mandatory to use the online process. And employers must check status via an online portal, verify the information in person or with a video call, and then download the evidence to retain on file. Checks for employees with electronic visa status, so including EU nationals, are already required to be completed via the online portal. And what the Home Office has said is that in future, they plan to move away from right to work checks using physical documents, and are looking at developing a tool to allow for online checks to be done for Irish and British passport holders, so that they can also get their documents checked via the online process. And this would make remote checks much easier and more secure for employers across the board.
That was all we wanted to cover today. Do look out for the third and final webinar in this series, which is on employment contracts and changing terms. If you have any questions about anything we've covered today, please do get in touch with any of us. And it just remains to say thank you for watching today, and we'll see you again soon.